Chapter 25. Assailing Judgments of Courts in General Jurisdiction by Habeas Corpus. Part 1. In Criminal Case. Section 369. Sentence by Court or Judge de facto. It is well settled that the writ of habeas corpus cannot be used as a substitute for a quo warranto. One convicted by a jury and sentenced in a court by a judge de facto, acting color offici, though not de jure, and detained in custody in pursuance of his sentence, cannot properly be discharged on habeas corpus, as where one had been indicted, tried, and convicted and sentenced for a felony in a court presided over by a judge disqualified to hold office under the 14th Amendment to the Constitution of the United States, but who had been in office 2 years before the amendment was adopted. Again, where the relator was convicted by a justice of the peace as a delinquent road hand, he appealed to the county court and was again convicted. He then, on habeas corpus to the Court of Appeals, set up alleged ineligibility of the county judge in holding incompatible offices. But the court refused to revise the judgment, and gave as the result of many authorities reviewed that in the matters which concern the public of the officer's title to his office, he, being in the exercise of its duties, cannot be questioned unless in direct proceeding having for its object the contestation of his right to hold the office, and the appointment of one to an incompatible office with the one he holds at the time of appointment, is not absolutely void. The first office becomes vacant on his accepting the second and qualifying for it. For same rule in Louisiana, seeing cases cited. In Massachusetts, the Supreme Judicial Court holds that when the court has jurisdiction of the case and of the party, and the warrant is sufficient to justify the officer, and the prisoner has no special privilege or exemption, his imprisonment is legal, and the law does not allow the authority of the judge by whom the court was held and the warrant issued to be disputed in summary manner by a writ of habeas corpus. In Wisconsin, where one was indicted, tried, convicted, and sentenced for a felony at the term of the court held by one who exercised the office of judge under an appointment by the governor, by which was made without authority of law, and against whom a judgment of ouster was afterwards rendered, the sentence was held valid and binding, and the Supreme Court said the discharge of the prisoner by the county judge on habeas corpus was wrong, and they reversed his judgment.